record. So I'm going to record the formal presentation with Gill, and then I'll stop recording when we do the Q&A, so you'll be able to ask any questions that you've got. So first things first, thank you so much for joining us, and it's an absolute pleasure to introduce the incredible Gill. Gill has been working, she co-founded, so if we can all do it, ooh, she co-founded the Open Justice Court of Protection project in 2020, and she's got a massive background in advocacy. I think you said 15 years as a disability advocate. Gill explained that she's a disabled academic and an activist, but yeah, she's got loads of experience in advocacy, which I think is really important on these sessions, because she'll understand where you guys are coming from and what it's like to be an advocate. So you can ask loads of questions. The slides that Gill's going to use today, we will make available after the session. So feel free to make notes, but you don't have to if that's kind of a bit overwhelming. We will send you all the information. Thanks, Leah, for the ooh in the chat box. Yeah, or can we get a whoop whoop? Over to you, Gill.
You've just reminded me, Kate, actually, of speaking at one of your conferences one time when you had some quite powerful introduction music. It was like, I've never been pumped for doing a talk in my life, I don't think.
Good, woohoo! Yeah, we'll get some salt and pepper going. I think.
Oh my goodness! Right, I'm just gonna share my slides with people. Like Kate said, slides are going to be available afterwards, and I've got various things that are sort of hyperlinked in the slides, so you should just be able to kind of navigate to the different sort of sites and things I'm going to talk about from these slides. So it should be kind of as easy as possible, I hope. So yeah, so the purpose of this quick session today is just basically to introduce the Open Justice Court of Protection project to you, to explain oh, hang on, I'm sorry, I knew it was too good to be true. I've got some timing going on this slide or something. Right, well, don't know what's going on there, but I'll do my best. So yeah, to introduce the project to you, to introduce something about how it works, how we support people to observe the Court of Protection, how our blog works, and what we can offer for you, how you might like to get involved with us, that kind of thing. So how to observe the Court of Protection in action, and why you as advocates may want to do so, may want to encourage other people to do so. So just very briefly, I'm just going to reflect on why transparency and open justice matter, because they're well-established principles, kind of democratic sort of principles about why it's important for justice, as we know the saying, not just to be done, but to be seen to be done. So here's a couple of quotes. One from one that really kicked off transparency in the Court of Protection itself. So starting off with the top quote, it says, "Open justice. The words express a principle at the heart of our system of justice and vital to the rule of law. The rule of law is a fine concept, but fine words butter no parsnips. How is the rule of law itself to be policed? In a democracy where power depends on the consent of the people governed, the answer must lie in the transparency of the legal process. Open justice lets in the light and allows the public to scrutinise the workings of the law, for better or for worse." And I think there's so much in there for advocates. You know, the idea of scrutiny will sit very closely with people who've been involved in any work like watching briefs or anything like that. It kind of, to me, it's quite a close fit with the idea of advocates kind of scrutinising the work of institutions and how they impact on people's lives. And the second quote is an older one, and it says, publicity is the very soul of justice. It is the keenest spur to exertion and the surest of all guards against improbity. It keeps the judge himself or herself while trying under trial. Sorry, I need to go back. These slides are not behaving. So basically, open justice is central to the operating of the legal system in a democracy, and it's something that we can all be part of, that we've all got a right to, and that we've got a responsibility to be involved in my view. And as people will probably know, in the Court of Protection, the idea of transparency and of the Court of Protection being a place that's open to the public has really been in practice, has really been a thing since 2016. Before that, much of the work of the Court of Protection took place in private, but since 2016, with the transparency pilot and now the formal rules that are part of the court's procedural framework, that presumption has been flipped on its head, and much of the work actually happens in public. So that's the kind of the context in which we are working as the Open Justice Court of Protection project. We don't have to, we're not kind of trying to sort of, you know, bash down the doors of a secret shadowy court. Those doors are kind of open to us, so that's good. Moving on, and I'm going to go through these quickly because I want to get to the practicalities of how you can get involved. So just some reasons why you might want as an advocate to observe the court in practice. So firstly, to see law in action and observe how the Mental Capacity Act 2005 is applied in practice. Linked to that, to observe person-centered and rights-based reasoning in the Court of Protection. And I think there it's important to sort of stress that you get so much more out of watching the court in practice than you do from just reading a published judgment. Things like hearing arguments that were rejected by the court, things that, you know, arguments that lawyers tried to make that didn't work out, and things like that. You can really get a lot from seeing what actually happens and how things transpire in practice. Also, health and social care and other professionals tell us that observing the Court of Protection action helps them to better understand how the law works and contributes to their professional development. It gives them an indication of what would be expected of them if they were involved in court proceedings professionally. And I think Kate has kind of more to say about how observations can fit with professional development in terms of the advocacy qualification frameworks and things. So that's all stuff to bear in mind. Also, what advocates love to do, we love to speak truth to power, and you can do this with our project through writing some of the blog posts that I'm gonna show briefly in this talk, and getting involved in that way, highlighting concerns or critiques or just reflections on decisions that you've observed the court make and how they've impacted on your practice. And also you can engage with other observers through writing multi-authored blog posts. We've got several blogs on our website that are written by different people from different perspectives, people who occupy different roles, and come to their observation of the court with different perspectives. And that can really open your eyes to how, you know, maybe if you were observing a hearing that, say, a social worker was observing as well, and you come together and reflect on that hearing together, you can begin to understand how some of the people who are impacting the lives of your clients in different professional contexts really understand and come to these kinds of decisions. So there can be a lot there for that as well. Coming to the Open Justice Court of Protection project then, we being Celia Kitzinger and I, founded the Court of Protection, the Open Justice Court of Protection project in June 2020. It was one of the less dreadful things to come out of the pandemic, I think. Basically, one of the biggest motivators or spurs or catalysts was the fact that due to the pandemic, the vast majority of the court's work began to take place remotely, and that meant that as observers, we were able to actually access the court from our own homes, or subsequently from our offices and places like that. So we didn't actually have to go to the court and sit in the court. I've done that myself before, and Celia has as well. For myself, I did some of my PhD research in the Court of Protection in London, that building that's on that slide there. I spent a month basically hanging out there and observing what happens. But obviously for professionals with kind of busy working lives, and as advocates you'll know yourselves, if you've got a heavy caseload and you've got lots going on, you can't necessarily spare a half day or a full day to travel to your local Court of Protection and see what's going on. So certainly the remote, or now the sort of the hybrid nature of hearings, has been a strong catalyst that we've kind of harnessed to make transparency a thing in practice. As I said, in theory it's been a thing since 2016, but in practice people, it wasn't something that was necessarily able to work for a variety of reasons. So things that we do, one of the main things that we do, and this is perhaps quite strange to anyone who knows that that the courts publish their listings on a daily basis. Anyone can look online and see what's going on in the Court of Protection tomorrow. One of the things that we found, though, one of the biggest practical kind of challenges to observing the court in action, is that the listings can be a bit of a mess. Hearings listings are published in various different places. If you want more information about all that, it's on our website. Basically different places, but they're not consistent, they're not necessarily accurate. Sometimes they're just not exactly user friendly for people who are not lawyers. So what we do is we troll the listings every day, and we find ones that are likely to be particularly accessible, and we put them on our website, which you can link through these slides, but it's openjusticecourtofprotection.org. We have our featured hearings on our homepage every day, and you can go there and basically you find the details of the hearing and sign up to observe it, and I'll explain that more on the next slide. But yeah, we share court listings. Sounds quite boring, but it's a big practical step towards making open justice a reality. I mean, you probably know for yourselves, not all activism is glamorous. Sometimes it's kind of doing the same thing lots of times and kind of making the wheels of action kind of turn. And we report on hearings that we've observed. So our blog, which again is on our website, has got well over 100 posts on it now, with from different perspectives on a range of different kinds of hearing. Whatever it is that you might be working on with a client, be it where they're living, be it who they have contact with, be it access to medical treatment, be it facilitating sexual relationships, be it whatever. We've probably got a blog on our website that deals with a case before the court on a similar topic. So that in itself, even if you're not necessarily in a position to observe the court in practice yourself, certainly our blog can be a rich source of information and reflection for you. So I'd suggest certainly checking that out. We also provide links to published judgments. You probably know that the Bailey website, British and Irish Legal Information Institute website, publishes judgments from all of the courts. Not many from the Court of Protection. Not many Court of Protection cases end up in a published judgment, but when there is a judgment from the court, and particularly when it links to a case that we've observed, then we provide links via our website so that people can actually read the judgment itself, how not only the decision but how it was made, and the mechanics behind it. One of the reasons why we're kind of so committed to that is because, like, you've probably come across yourselves, that the sort of headlines in the media that sort of describe the outcomes of court of protection proceedings, but often in kind of the most salacious ways possible, or the most kind of black and white ways possible, without reflecting the actual kind of the reasoning of the judgment, or the kind of the nuanced issues around the reason why the decision was made about a person's capacity, or about, you know, what's in their best interest. So we feel that actually linking people to the actual judgment itself can be a way of people informing themselves and kind of educating themselves on that. We provide information and practical support to public observers. So if you decide that you want to observe the court in action and you find that you're struggling, you can drop us an email, or you can contact us via Twitter, and we will do everything we can to help you with accessing hearings that you're interested in. And we share updates on developments in the Court of Protection as public observers, to get involved with the development of open justice in the Court of Protection itself. So particularly at the moment, we're working with the court on how listings happen, and what the process is around getting listings more accessible and more consistently accurate for members of the public, and also providing that bridge between the public and the court. So when I did my research back in 2017, what I heard from a lot of court staff was a sense that they resented the transparency agenda, because basically it was a lot of extra work for them, but nobody actually came in reality. So they kind of didn't see what the point was. But then from the public's perspective, they didn't really know that transparency was a thing, or they didn't know how to go about accessing the court. So that kind of bridge is another role that we take on. Let me move my slides on. So this is basically what a featured hearing post will look like, and we provide the details of the hearing, the case number, the judge that's hearing the case, where it's taking place, and then we provide the details for how to actually go about asking for access to the hearing. So that's what you get from our homepage. And like I say, we do this every day, so it's always worth going and taking a look and seeing what's available and what you might want to take a look at. And then when you do that, when you've decided that you've got some time to observe the court in action, how do you go about doing that? Well, the first thing to stress is that pretty much all of the hearings are actually in public. It doesn't always say that if you look at the court's actual listings themselves, because when hearings went remote, basically the transparency provisions got kind of switched off, and it hasn't always been reflected in listings that they're actually back on. But basically, almost all hearings are open to the public. Importantly, not dispute resolution hearings, which are a kind of judge-led mediation proceeding. So if you ever see DRH in any listings that you're looking at, that basically means they're never open to the public. You can get access details via, like I've said, our home page, or also our Twitter feed, which is linked to there. So we tweet about a vast range of hearings as well. We tweet more hearings than are reflected in our featured hearings. So that's another source of information as well. And then basically you send an email to the court staff asking to observe. You're not asking for permission to observe, you're just asking for access, basically. There's a template letter on our homepage if you scroll underneath where the featured hearings are, so if you're struggling with how to word it, you can get the template letter from the homepage. And then you should receive an email with a Teams link, or the cloud video platform is another platform that they use. So you should get a link to a video hearing. Lots of the regional courts use phone hearings though, so you might be phoned either by the judge, or sometimes you're asked to call into a conference line. If it doesn't say that the hearing you're looking to observe is by video, it's worth including your phone number in the email when you're emailing to sort out access. It just stops them having to email you back and ask for it. And you must be in a quiet place when you're observing the court in action, where you can't be overheard and you're not allowed to record the hearing, obviously. And you must comply with the transparency order. That's the reporting restrictions that basically typically say that you can't write or discuss anything that would possibly identify P or a member of P's family or various other parties involved in the hearing. You should be sent a copy of the transparency order for the hearing when you're given access, and if you're not, you can contact the court staff again and ask for a copy. And then when you get into the court, into the hearing, it should start with a summary of the case. So you should, usually it's the counsel for the applicant will describe what's happening in the case, and you should get a summary of it. We have I know I'm kind of running out of time, but I'll just finish these last points. We also have a feedback form that you can use on our website. Basically, you can download that, and it asks various questions. And the reasons why that might be useful to you are, firstly, to help you structure and make sense of what you're seeing, so you can kind of understand that you're taking in the key points for your observations. And then you can forward that to us if you like, and basically contribute the information to the project about what you've observed. Or you can use it to help structure a blog that you might want to write yourself about your own reflections and what you saw and how it's impacted you. And that's obviously hyperlinked there at the top. I'm just finishing up now, but just to kind of say that as well, that we've got a blog with several lots and lots of different hearings, different observations. Again, you access the blog via the website, and there's an index of all different kinds. Basically, we have two different types of blog. We have the ones that are observations of court hearings, and then we have ones that we've commissioned from various different types of expert, be it legal experts or health experts, or different sort of perspectives on the work of the court, on what different things that you might see in your observations, what they actually mean, and kind of what's going on. So those are the two different kinds that we have. These are some blogs from January of this year. Patient dies in hospital as trust failed to comply with mental capacity at 2005. Capacity and elective cesarean. On care, coercion and childbirth in court of protection. Abuse and coercive control, a fact-finding hearing, and exoneration. So you can see there are various topics that are going to be useful to advocates in terms of how the law is applied and how it kind of relates to the different issues that might be affecting some of your clients. Obviously, the court has been concerned a lot with COVID and best interest decisions for people who lack capacity around COVID vaccinations and access to care homes and things like that. This is a case study that I'm not going to go into now, but it's a blog that was written by a trainee IMCA, so it's particularly interesting for advocates about something that she observed. And then there's comments about how the observations have kind of fed into her training and how the kind of impact they've had on her. So that's worth taking a look at, and certainly reading Hillary's blog as well. These are details about where you can find us, our website, our Twitter handle, our email address. And yeah, basically get involved, do some observations, write us a blog, keep in touch, and all that kind of stuff. Sorry, I went slightly over time there, Kate.
That's great. Thank you. Sorry, I've just got a coffee machine in the background. I was hoping you'd speak for another 60 seconds. So.
Oh,
Didn't
sorry.
hear me.
I was trying to run.
No, perfect. Absolutely perfect.
Thank you for the claps as well. Better that's really kind.
Yeah, brilliant. Okay, so we will go over to Q&A for now. So I will stop recording and invite anybody to pop on their cameras and come on mic. There's a couple of comments and chats in the chat box.
Okay.
Sorry. You want to take a minute to read them, Jill?
Yeah, I